Okay, at this time, I would like to bring Dr. Fry into the discussion. Dr. Fry, to a lot of us lay people, this whole area of mental impairment seems a little bit amorphous in that, as opposed to a physical impairment where you can, for example, see a broken leg and just say, well, these are the functional limitations of this individual until the bone heals in terms of lifting and carrying. I mean, it's sort of easy to quantify. In the area of mental impairments, and it seems like when we hear terms like affective disorders, we've heard the word bipolar mentioned. There are certainly personality disorders and other organic mental syndrome. Can you help us get a picture of or a technique on how to picture what the functional limitations are, whether they're in concentration and memory and ability to relate to coworkers and supervisors and the general public, so that we can have a basis for knowing what accommodation should be requested?
Yes. I'd like to, it's interesting to me that the amount of history that's been brought into the picture already by various speakers has taken place, and I'd like to add to that a little bit, because I think that this specific question that Mr. Bruce has asked is an important one, but it needs a background. It needs, I want to broaden the picture a little bit from this rather specific issue of what disabilities are to the historical issue of disabilities. And I'd like to take about 10 minutes. I prepared some material here in that regard with that concept in mind. I'd like to take about 10 minutes to paint this a picture of history, the background. And I also wanted to say something about where I fit into this picture as well. I'm a psychiatrist. I'm a behavioral scientist also. As a psychiatrist, I've had an office practice of psychiatry from 1953 to 1990. That's down the road in Menlo Park. And then my research work has been carried out under the auspices of Stanford University Medical School. But during the past, since 1990, actually during the past 15 years, I've been doing work as a disability workers' compensation evaluator. And that's where I'm coming in, my experience is coming from that particular activity. I would like to point out also from that standpoint, as opposed to the lawyers and also the rehabilitation experts in this field, that as a psychiatrist, I'm in a position of presenting material, diagnoses, and information that patients, employees have supplied to me, to the employers, and specifically to the disability judges for determination of workers' compensation settlements and so forth. The journey away from discrimination and equal justice is not over. I'll give you some examples. What I want to do in that regard is to give you some examples of reform that are being called for by the American Psychiatric Association, the organization that the professional organization I belong to, because it gives you some understanding of what this organization feels about the frontier land that continues to exist in this whole field of worker compensation and also the issues of disability. They have programs that are active at the present time in the headquarters of the American Psychiatric Association in Washington, D.C., introduced securing reintroduction of legislation to repeal Medicare's discriminatory 50% co-payment required for outpatient psychiatric services. Developing a response to Medicare's lack of coverage for so-called intermediate level psychiatric services, for example, the residential and non-residential care that is less than hospital level intensity, but more intensive than the outpatient office-based treatment. And addressing also the discriminatory 190-day lifetime limit on inpatient treatment in psychiatric hospitals. Another item is continuing active support for strong physicians and patients' bills of rights, with emphasis on ensuring that provisions do not discriminate against psychiatric patients. Working to ensure that any Medicare prescription drug package includes non-discriminatory coverage of psychotropic medications. Assessing wide variations in Medicare coverage of psychiatric services, where appropriate, seeking positive resolution via regulatory or legislative fixes. Securing passages of mental health parity legislation that repeals the current September 2001 sunset date of the Parity Act, which has been already passed and is active, and expanding the scope of parity requirements. Lobbying for inclusion, all of these are programs which are actively carried out by various committees and various individuals in the American Psychiatric Association. Lobbying for inclusion of non-discriminatory utilization and review requirements as part of parity or managed care reform legislation. And also they're interested in continuing protection for funding for mental health research, which is an important consideration for the future of what we all are interested personally in one way or another. Now, another issue having to do with current factors in psychiatric disability, a major issue being addressed by the federal government is the matter of sustained parity in insurance coverage for psychiatric illness. And I'm referring here not to functions or activities of the American Psychiatric Association, except in terms of lobbying, but rather actions that are being carried out in our legislative bodies in Washington. The Congress, the House of Representatives, and the Senate, and 2-3 individuals who are carrying this mission, this crusade very actively at the present time, is Representative Rukima of New Jersey and Senators Pt.2 of New Mexico and Paul Wellstone of Minnesota. Those are people's names who you might have interest in jotting down for future reference in terms of contacts. Recently, a Republican representative, Rukima, was quoted, "As a society, we're still struggling," I think that's the point that I've been trying to make here, "we're still struggling to acknowledge that mental illness is a real illness in need of medical care. Mental illness is not a character flaw, but a tangible, treatable health problem as real as hypertension, cancer, or heart disease. Mental health care is as effective as insulin for diabetes. We must address the largest obstacle in the way of Americans obtaining that effective medical care, namely inadequate and discriminatory insurance coverage." And that's what this legislation that she's referring to is all about. The tragic irony in the current way that the insurance industry views mental illness coverage is that most people who suffer from mental illness can live normal lives if they receive treatment, but most cannot receive treatment if their insurance doesn't pay for it. The bill goes beyond the current status, and it's known as the Mental Health and Substance Abuse Parity Act, extending insurance parity to co-payments, visit limits, deductibles, and out-of-network charges. But I wanted to bring forth the fact that this bill being promoted by the representative and the senators that I spoke of earlier also has provisions that state that the substance of the bill applies to issues of substance abuse and chemical dependence benefits, as well as other forms of mental health care. In other words, it's expanding the issues of the definition under the law. Now, I'd like to comment also about another factor that is an indication of the active state, and unfortunately, it's the movement is a backwards movement, and this happened last week, just to bring this completely up to date, and that has to do with the repetitive motion prescriptions or regulations. These regulations are issued by federal government, as most of you know, to protect what they've estimated is over 100 million American workers from the epidemic. And from my personal experience with workers' compensation over these past 15 years, that the word epidemic is not an exaggeration, is not a misnomer. Epidemic of repetitive motion injuries, which have been a source of great alarm in this country and also in other countries where anybody is working in any kind of repetitive job, repetitive motion type job. Although you could say perhaps that this is not affecting directly the issue of a mental disability or psychiatric disability, but in fact, in my experience, there's been a very strong connection between the repetitive motion problems, such as carpal tunnel, tendinitis, sprain and strain, bursitis, and arthritis, and psychiatric disabilities that are oftentimes derivative in relationship to these physical disabilities, which have become so common at the present time. And I think it's unfortunate. Now, I'll have more to say about that later on. We get talking about some more specific factors, get down to earth. Before we go on, I want to bring to your attention that there are 2 booklets that are available with regard to mental illness and fighting discrimination against people with psychiatric illness. And both of these are produced by the federal government and available through telephone number, anybody wants to write down, 800-789-2647. And the first one is entitled Participatory Dialogues, a Guide to Organizing Interactive Discussions on Mental Health Issues Among Consumers, Providers, and Family Members, and describing how different organizations or individuals can organize meetings and form partnerships and so forth with hope to lead to improvements in mental health services. And the second booklet is entitled Filing an American with Disabilities Act Employment Discrimination Charge, Making It Work for You, addresses disabled individuals who feel that they've been discriminated against on a job due to a disability, and instructs individuals with regard to filing charges and how to file, document, and present a charge effectively.
Dr. Fry, if I can just briefly say this, you have described various spheres of where the word disability comes up with respect to disparate treatment by insurance carriers. You've referred to the workers' compensation system, the Social Security system, other laws, regulations, private and public entities involved in this general area. I think it's important to note that when you get into each of these spheres, that the definition of disability is certainly not the same. For example, I'm a Social Security practitioner, which has a very strict definition of disability, and it is totally different than the workers' compensation definition of disability, which again is unlike the definition that we're really talking about today, that is what constitutes a disabled individual in the sphere of employment. So I think it's important to keep in mind that those differentials have a dramatic effect on how people are treated. It's very basic, whether it's a liberal definition, whether it's a strict definition, as in Social Security. But we should all keep in mind that all these areas are important, but very dissimilar in that respect. Okay, Dr. Fry.
Now, carrying this a little bit further in the direction that Mr. Bruce is, I'm sure, desirous of having me make some comments about, I've put some categories on the board here. These are all categories in general terms. These are not diagnostic terms, and these are not legal terms in a specific categorization, but they're general categories, and I'm sure anybody can recognize from the standpoint of the educational experiences and the life experiences that any one of us have had. This is organic mental diseases. The next one speaks of psychotic disorders, the second item here, and of course schizophrenia is the most common of those, but also includes other issues of such as the paranoid disorders as well. Affective disorders, I will speak a little bit more about those in the future. Mental retardation, anxiety disorders, and one of these is the obsessive-compulsive disorders. And we have somatoform disorders, and probably the most common one of those, of the somatoform, is the pain disorder, somatoform pain disorder, which is frequently accompanied, I was speaking a little bit ago about repetitive motion. This and depression are the two, somatoform pain disorder and depression are the two psychiatric conditions that I have seen over these past years more commonly associated with physical disabilities like the repetitive motion ones. Personality disorders, for workers' compensation, frequently those that category is taken to indicate a diminution of the eligibility of the individual for compensation. Then substance abuse and addictive disorders and developmental disorders, most common, most well-known of those is autism and other forms of learning disabilities.
Dr. Fry, if I can, now that you've gone through the general categories, what those of us who aren't psychiatrists need to know with respect to employment in particular is when we hear a diagnosis like depression or somatoform, where we know that the pain is real, whether or not there's an organic basis, is how do we know in terms of quantifying these things, in terms of functional limitations, whether it's used to determine the accommodation or the amount of accommodations, or in the alternative, to determine in a Social Security disability case whether it is mild. I use terms like mild, seldom, mild, moderate, marked, and extreme. I may not have said it in the right order. And so, believe it or not, psychiatrists actually testified that this is moderate impairment as opposed to mild, as opposed to severe. Could you help us in these categories, understanding them so that we can apply it to the workplace?
Can everyone see this well enough? Just to prove that I anticipated Mr. Bruce's, it's a logical and intelligent way to pursue this, and demonstrating my approval of your, I have already put this list of what we call is work function impairments. And this is a schedule which psychiatrists are asked to respond to when issues of disability have been established. In other words, a person has had a work injury which has resulted in a psychiatric disability of a permanent nature. And these refer to the matter of functioning in the workplace. And the first item, there are 8 of them. Item number 1 is ability to comprehend and follow instructions. For the sake of my repetitive motion issues here, I've only written down 1 or 2 words for each one of these items, but I'll read them off. Ability to comprehend and follow instructions is number 1. And the consideration has to do with the ability to maintain attention and concentration for necessary periods. Number 2, the ability to understand written or oral instructions. And number 3, the ability to do work requiring set limits, tolerances, or standards. And then we have number 2 here, ability to perform simple and repetitive tasks. And the items under that are the ability to ask simple questions or request assistance. And number 2, to perform activities of routine nature. Number 3, ability to remember locations and work procedures. Number 3, the major categories, ability to maintain a work pace appropriate to a given workload. And they consider the ability to perform activities within a schedule, maintain regular attendance, and be punctual, and the ability to complete a normal work day or work week and perform at a consistent pace. Number 4 is ability to perform complex and varied tasks, and that involves the ability to synthesize, coordinate, and analyze data, and the ability to perform jobs requiring certain attainment of set limits, tolerances, or standards. Number 5, ability to relate to people beyond giving and receiving instructions, and in consideration under that regard of work function limitations has to do with ability to get along with co-workers or peers, ability to perform work activities requiring negotiating with, explaining, or persuading, and the ability to respond appropriately to evaluation or criticism. Number 6 is ability to influence people, the ability to convince or direct others, the ability to understand the meaning of words and to use them appropriately and effectively, and the ability to interact appropriately with people. Number 7, ability to make generalizations, evaluations, or decisions without immediate supervision, involving the ability to recognize possible hazards, follow appropriate precautions, the ability to understand and remember detailed instructions, the ability to make independent decisions or judgments based on appropriate information, and the ability to set realistic goals or make plans independent of others. And then finally, the 8th is the ability to accept and carry out responsibilities for directions, control, and planning, and that involves the ability to set realistic goals or make plans independently of others, the ability to negotiate with, instruct, or supervise people, and the ability to respond appropriately to changes in the work conditions. Now, this is a very complex system, and I'm sure that you're not going to be memorizing each of these abilities or limitation in the chart. Each one of these can be rated on a basis of none, no impairment, and frequently that's the case with the limitation number 1, no impairment, and then you can have a rating of minimal impairment. Then there's a very slight, moderate, and severe. And as you can see, there's a wide range of intensity that can be modified too. So you have all 8 of these impairment potentialities, work functions, plus also the modifications in terms of severity that can be brought into the rating as well.
Well, Dr. Fry, thank you for that, but I've always wondered, from all the hearings I've been in, when they have a consultative examination report, a treating doctor's examination report, and then, of course, a psychiatrist who is supposed to give an expert opinion, who actually does the ratings, not that you just described. In other words, from mild to moderate, et cetera. How does a psychiatrist accomplish that? I mean, what is the basis for saying something is moderate as opposed to mild, or moderate as opposed to moderately severe, for example?
Actually, psychiatrists are not involved in that matter of quantifying. That's the responsibility of the compensation judges to take this impression that the psychiatrist has provided with regard to, say, for instance, the matter of being able to follow instructions, and that the question of the quantification that is indicated in the anywhere from no limitation, no impairment, to severe limitation or impairment, and the observations that contribute to that conclusion have to do with actual experiences that are described by the worker, the person who now has experienced a permanent psychiatric impairment, disability, that individual's subjective presentation, descriptions of participation or activity in the workplace, or that have become apparent during involvement with the rehabilitation process, or in many cases, or not many, but a few cases, I should say, the non-participation in the rehabilitation program, because that also is an indication of the individual's level of relating to others and following instructions. And also, in addition to that, the indications that have come forth as a result of the psychiatric examination. See, these are not judgments that are made out of a clear blue sky and by somebody, a professional, a psychiatrist or psychologist, imagination. They are also have specific contribution in terms of observation and history, is what I'm trying to say.
Dr. Fry, is there any authority that you can point to where a psychiatrist would be able to look in a publication to explain why any of the functional limitations that you went over is moderate as opposed to severe in terms of quantifying it in those levels? Although in certain areas of law, it isn't the job of a psychiatrist, I can tell you that in Social Security disability, it certainly is. And they are non-treating, non-examining experts who testify at a hearing, and they are asked to state, is the limitation, I don't know exactly how it goes, but anywhere from mild, moderate, severe, extreme, marked. And I've never figured out exactly on what basis the psychiatrist comes to that conclusion.
This is where the art of the profession comes in, rather than, we don't have a computer or a calculator to check out the degrees, and it's a matter of experience in terms both of the specific individual who has shared their experiences with you in the examination and the evaluation, but also the experiences, what's shared in contributing to your judgment with regard to the experiences that you've had with many other individuals who have been in a similar situation with you as a professional. In other words, disabled workers who you saw 15 years ago.
Okay.
It would help me if you would perhaps give an example of one of those terms and maybe a 1-minute case history of a patient who came in you looked at that patient and you concluded on the basis of your visit about comprehension or one of the things that would you be able to do that?
Yes, this is actually, very easy in one particular instance that I'm thinking of, and it has to do with an individual who's having problems with supervisor. And I'd like to make some comments. I'd like to hang on to that word supervisor because I'd like to make some comments let's see what time we have, about supervisors. And that's I think, a very crucial factor. But this is an individual who's having trouble with a supervisor who was himself probably having a disability in terms of the ability to relate to other people beyond giving and receiving instructions. This supervisor is able to relate to people in giving instructions and receiving instructions. Yet the ability to relate was impaired to the extent that this particular individual, whom I saw in evaluation, had become stressed because of his experiences with that disabled supervisor. The disability of the supervisor, you understand, was not identified as such, but the proof of his difficulty with work function number 5 was in the fact that the person who reported to him, the identified patient in this case, had suffered as a result of that supervisor's difficulties in relating to people. And so in my evaluation, the injured worker, in my perception, did not have any permanent disability. The disability was of a temporary nature, and by the time he had returned to work after 3 weeks of recuperation at home, the prescription of a mild tranquilizer, Xanax, in case anybody knows what that is, and for a period of a week or 2 weeks, and he's ready to go back to work. The problem is, in this regard, in this case, is that the supervisor is continuing to be a supervisor. And the man's going back to work, and he's facing the same problems that are going to arise. Fortunately, in this case, we have a company that is far-sighted and informed enough to realize that there's a problem there, and so the supervisor comes under some scrutiny by his supervisor, and certain regulations, certain prescriptions are given to him with regard to his behavior in regard to the relationship between himself and the injured worker. That, I think, refers to this issue here under the ability to relate, to respond appropriately to evaluation or criticism. And the worker that I'm referring to, the injured worker, was back to work, had been back to work for about a week and a half or so when I had the evaluation examination with him. And he was doing fine because the supervisor had responded to the criticism that was given to him, and instead of changing his manner, he began to avoid this particular patient and be very, very matter of fact and very, very formal in his interaction. No more shouting and cursing.
And I could jump in actually here and give the legal analysis that goes along with this supervisor issue, because this is really common that people will call me up and they'll say, you know, I was doing great with my first supervisor for 6 years, you know, we got along great, this person loved me, they told me I was doing a great job, I was happy. New supervisor comes in who's negative, hostile, passive-aggressive, whatever, you know, usually the person's telling me about it is telling the truth. This new supervisor stinks. And the person really starts to become more disabled, more symptomatic, more depressed. And what do you do in that situation? Some advocates have tried to ask for the person to switch supervisors as a reasonable accommodation. For the most part, the courts and the agencies have been extremely hostile to this accommodation, even though it's a low-cost accommodation that's really what the person needs. So this is really unfortunate that legally that's a really tricky one to get. What we try and do is we don't call it switching supervisors, we try and call it a transfer to a vacant position, or we say something like, we need this person's supervisor to modify their methodology so that they, give positive feedback along with negative feedback, they don't engage in yelling, that type of thing. And I think that whole thing about permanent versus temporary has come up in the courts around the switching supervisor issue, because the courts will say, well, you only have this problem when you're around this bad supervisor, so how can you have a disability? It comes and goes with the supervisor, that's not a disability. And the courts have kind of missed the boat on the idea that a disability can be quiescent for a while, can be in remission, and then can be triggered by a stressful situation. So that sort of social context of disability is kind of completely lacking in the court system.